Okay, next up we have case number 18-2041, Goodall versus State of Florida, and we'll give counsel a moment to get settled in. Counsel, take your time, but whenever you're ready, just if you could let me know how much time you'd like in rebuttal.
I think I'd like 13 and 7, 13 for the first half and 7 for
7 in rebuttal?
Yes, Your Honor. And Your Honor, I'm sorry, my asthma's kicked up since I come in the building this morning, so I want to apologize for calling today.
No problem. Take your time. If you need another moment, that's fine, counsel. And just whenever you're ready,
Thank you. May it please the court, counsel. Your Honor, in this case, Mr. Goodall has demonstrated that the court erred in denying his 3850 motion. He has proven that counsel was deficient, counsel's performance was deficient, and that he was prejudiced by counsel's performance.
Counsel, there are a lot of issues in your initial brief. It's difficult sometimes to fully address that many arguments in one brief. So why don't you start out by telling us which argument, if you had to just pick one, and we won't make you just pick one, but what's your best argument?
Your Honor,
and why?
The best argument is the argument we let off with in the brief, and that is that on issue 6, the fact that counsel did not follow up on the alibi for the Horvath fire. In other words, Williams' rule was impermissibly and harmfully and prejudicially admitted of the Horvath fire when Ms. Gilmore was available, present, willing, and able to testify that Mr. Goodall was with her on the night of the Horvath fire.
You know, when I read the testimony, that the trial court noted that Ms. Gilmore on this issue, that her testimony was contradictory, and it seemed like that was a fair assessment, right? Walk us through why that is not the case.
Your Honor, she was never specifically asked. She was asked directly, have you talked about this issue with Mr. Goodall?
Well, what she did say, though, hey, when he woke up, I told him that Horvath called and said he set the house on fire, and he said she's crazy.
But
that seems inconsistent with, hey, he didn't do it. I was with him the whole time. I never talked to him about it, right? Yeah.
Well, in her defense, she testified at the hearing that she did not think a discussion was that little bit of an exchange of, this is what Vicki just called and said, and he says, that's crazy, and they never spoke about it since. To her defense also.
I mean, that's a pretty significant conversation, right?
Not until
somebody calls you and says, he set my house on fire, and then when he wakes up, your client wakes up, you say, oh my gosh, somebody accused you of setting their house on fire. That seems like a significant conversation.
I think to most of us in this room, that would be a significant conversation. I think as Mr. Carranza, which is the trial counsel, aptly put it, these are Pine Lakes witnesses. That was a running theme of what he said. In other words, they were poor, they were white, they lived in trailers, they didn't matter. They all had felonies, they all lied, they were all using drugs, and they all had memory problems. Not one witness in this case, barring Betty Root and Jay Colwell, did not have those same issues. There seemed to be a pervasive issue that the things that would matter to Your Honor and I, and to this courtroom and I, didn't faze these folks because their lives were somewhere other than where we are in our lives.
Counsel, and I understand what you're saying, but when we look at trial counsel, the shoes that he was in, right, at the time, because we're not supposed to Monday morning quarterback it, right?
That's correct.
Trial counsel looks at the statement, hey, I got this call. When he woke up, I told him about it. He said she's crazy. You can certainly, it seems like it's not unreasonable for trial counsel to say, gee, those those two statements are, are inconsistent with each other. She had this conversation. She told him. He said she's crazy. That's inconsistent with saying, I don't know anything about the fire, and I never had a conversation with him about it.
Your Honor, I would respectfully disagree for the following reasons. Counsel in this case was acting under an active conflict of interest, both with his other attorneys in his office and himself personally.
That's a different issue, and that's an interesting one as well.
But it all goes together, and that is the real problem with all of these issues. You can have the one issue, but they all intertwine, and they all overlap, and they all interlink. Counsel didn't inquire. The problem that counsel has, while it appears on its face that Your Honor's question that tract feels reasonable and it sounds like sound trial strategy, it's not, because counsel still had the duty to ask. He was having conversations with Ms. Gilmore. His client consistently kept telling him, wrote him a letter which counsel agreed that he received after they had already agreed on a strategy. Afterwards, he'd received that, and that was another problem with the court's order. The court got that wrong. Saying, please, go talk to her. Go talk to her. This was before she wrote anything. This was before the Williams rule. Counsel didn't even investigate, and therein lies the real problem. He's proceeding on an accidental fire theory. He doesn't preserve the fire scene. He doesn't look at the fire marshal report, which would have said that the canine was wrong. He doesn't talk to all the witnesses. Those witnesses he talks to, he doesn't call them at trial. He doesn't follow up on Ms. Gilmore's statement. Had he followed up and Ms. Gilmore got on the stand at the Williams rule, there was only two things that were going to happen. The judge either says, no, I believe Ms. Horvath, and you're lying, Ms. Gilmore, which damages her for trial if the state uses her at trial, or B, you know what, there's not clear and convincing evidence, Williams rules out. There's only two options there. There isn't a third baby. There's nothing to split there. So counsel erred by not even investigating, by not following up, by not being prepared. And he did this throughout. He admitted this Williams rule, which was clearly harmful. The Wilson case is clear on that. He did the same with all of the lack of preservation of the trailer. He proceeded on this accidental fire theory. They had the case for 5 months. He had the case. The office had the case for 5 months. They didn't preserve the AC. They didn't preserve the trailer. It gets destroyed. His expert is left with what the fire marshal had said is, we thought there was a problem, maybe at the AC. There's where the origin of fire was in that area. They looked over. That was all the fire marshal did. That's the testimony. Experts left with photos. And a defense expert does no good if you hire them. I don't care how much money you spend on an expert. If the expert can't test it and figure it out and look at it and take it apart. Furthermore, they hired 3 or 4 experts. They called one at trial. One. And that's the expert. And none of the experts could look at the scene. The expert testified at trial at pages 1501.
Would it have mattered if they had called 3 experts?
It might have, because the jury would have heard about the AC. Expert Brill, who the court would not let us get into, but we proffered about, actually was an expert in the air conditioning arena and the electrical issues with regards to fires. He said, look, we could have taken that thing apart. We didn't have it. We can't show that, you can't show one way or the other. Had they examined it, had they had that expert, he could have poked holes or pointed out that the fire marshal should have done X and should have done Y and should have done Q and should have done P. That was never brought out at trial. There was no real attack on what the fire marshal did. And frankly, proceeding on an accident...
Well, I mean, but we don't know what it would have shown now, right?
We don't, but either way, it would have helped the defense. Either way.
Okay.
If it had shown it was an accident, that clearly would have helped the defense and maybe convinced the prosecutor that it was an accident, and it was certainly provided some information for the jury and evidence for the jury. If they'd have determined it was arson, then maybe counsel would not have forgave and forewent the accidental or the alternative arson theory, the additional arsonist. And he had plenty of people to point a finger at. He had Gilmore, who had threatened, who had stolen, who had forged checks.
Which I find that sort of interesting, right? You know, your client would rely on Gilmore as an alibi witness, right, for the Horvath fire, but at the same time and at the same trial point the finger at Gilmore for the fire at issue here. That seems like a difficult position for trial counsel.
I don't know that he would have had to have pointed at Gilmore, because there was Burnham, there were the Kingsmen, There were other people because of Burnham's work as a CI. There were other people to have pointed at, and there were other people with motive.
How does the Kingsman, walk me through how that plays out? How does that, who offers that? How does it get admitted?
Jason Burnham had been threatened and beat up by members of the Kingsmen. Jason Burnham had been a CI in 40 separate cases resulting in arrests, one very recently in Lake County. Jason Burnham was in the evidentiary opinion, was probably the prime suspect that if the fire was actually an arson, because his personal items were removed when the house was seen 3 days later. Pictures and photos and mementos weren't there and weren't burnt up. They had been removed beforehand. Jason Burnham...
except for the Gilmore was there right before the fire, apparently, and then was gone, and all of her kids were gone at 3 a.m. or 4 a.m. when the fire was set.
And this is all a problem, and the jury heard none of it.
Well, but again, how does counsel point the finger at Gilmore if he's going to rely on her for an alibi?
Well, he wouldn't have known whether she would have, until he had asked about that alibi and determined what she was going to say, he shouldn't have been making that decision. He was making that decision with blinders on. And therein again lies the failure to investigate and the failure to prepare. He did not follow any evidence. He didn't follow any leads. He didn't look. He never turned the first rock, which is what you're required to do to provide effective assistance to counsel. You're not required to turn every rock.
Well, counsel, it seems like he put on a very robust accidental fire defense. I mean, to say that he didn't turn over any rock, I think that is a bit of a overstatement, right?
Okay, I didn't say he didn't turn over any rock. I said he didn't turn over the rock, all the rest of the rocks. And he did not put on a robust defense, in my opinion. He did not, because he didn't preserve the scene. He didn't, when he had evidence of an accident, i.e. testimony from Herring, testimony from Sessions, testimony from Gilmore, testimony from Burnham, that the trailer was in disrepair, that as of the day before the fire there was problems with the electrical problems and the wiring in the trailer.
But that wasn't even the defense. The defense was the AC.
But it was, and all these people could have testified.
Well, how was it the defense? The defense was the fire started in the AC by accident.
Okay. And there was testimony at depositions which were admitted into the record. They are all this is in the record at various points, and I cited amply in my brief to all the points in the record. There were issues with the air conditioner. There were issues with the heater. There were
But the record doesn't say what the issues were. The record doesn't say that the AC was having electrical problems. I went and looked.
Well, but it does say that the breakers flipped, that the AC would shut the breakers off, that when you turn the heater off, the breakers would flip. There were that kind of testimony all over.
Where does it say the AC would turn the breakers off? I didn't see that.
I believe that it was I believe it was Miss Sessions that said that it was either the AC or the vacuum when she plugged it off, or Miss Gilmore that when the AC and the heater would flip the breakers.
In another part of the house, in the addition, not in the...
In the trailer, in both. And they were attached. They were attached on a single meter, on a single set of wiring. These were 2 pole barns that had been attached to the trailer as apartments. All of the wiring came through the main trailer. So no, he did not put on a vigorous defense. When he had evidence of the accident, he chose not to put it on.
Counsel, one question I had reading your brief was you repeatedly state that the cell phone, if counsel had gotten your client's cell phone records, and it would have shown that he was not in the area.
Yes.
Pinging from the towers.
Yes.
I couldn't find those records in our record to prove what you were saying, and you didn't have a site. So.
And I don't have a site because by the time I got this case, those records were gone. We requested.
So was that just sort of speculation that you put in the brief?
I wouldn't say it's speculation. My client.
I mean, you don't know what those records would have shown, do you?
Based upon my client's testimony and the testimony of the other witnesses I spoke with, yes, I believe I do.
But you're assuming, based upon your client saying I wasn't there, you're assuming the phone records would have shown that he wasn't there.
Yes, Your Honor.
Okay.
Okay,
and you're into your rebuttal.
Yes. I would, but I want to address 2 other brief matters, and I don't want to go much more into my. With regard to, Your Honor, I'll just deal with it in rebuttal.
Thank you, counsel.
Thank you, Your Honor.
All right.
May it please the court, I'm Carmen Corrente with the state of Florida. The first thing, as far as perspective goes, I wanted to mention that this court order was a 62-page order. It was done by the trial judge who read depots, who read, in some cases, grand jury testimony of all these witnesses, plus heard Williams' rule, lengthy, and a 4-day evidentiary hearing where all of these witnesses...
What about the conflicts
were
of
called.
interest, counsel?
Pardon?
What about the conflicts of interest argument?
Well, the conflicts of interest, it was never established really that Mr. Carranza had done anything of substance with any of these witnesses, that he would have represented them and been in a conflict situation. There was nothing in the record that showed that. The public
Didn't
defender...
he spoke with one of the witnesses, right?
One of those witnesses,
Wasn't it Burnham?
I believe he spoke with him, but I believe that was the one that had pled prior to, like a week before, that there was that communication. I thought he entered a plea right afterward or before he could even withdraw. Wasn't it Mr. Burnham? So, I mean, there still didn't establish anything where there was some kind of conflict. You have to be able to show that it was an actual, real conflict, and there wasn't one. There wasn't one in this record.
Does the record indicate whether Burnham was, after pleading, was cooperating with the state on this case?
I don't believe there was anything in the record about that afterward. Of course, Mr. Burnham died. He passed away. So before this trial, I believe, they had to preserve his testimony and bring him in, bring in the documentation. But no, I don't know where in this record that they show an actual conflict that was proven where they were in a position where they had to call a witness and ruin their plea deal of any kind. I didn't see that evidence in here. What I saw, though, was a judge who heard all of these witnesses many times, the 4-day evidentiary hearing, and found only one witness really not credible, and that was Renee Gilmore. Renee Gilmore wasn't credible, and it is explained in the order how that finding was made. And she didn't mention that she was his witness, an alibi witness, ever. She didn't mention that they had a conversation, and he asked her, he said, they're crazy if they think that I did it. Well, that's one thing that's an answer, that they had the conversation about it, that he denied doing it. Whether or not he was even there, that's the separate question that Your Honor mentioned, that on top of it all, why would you have that conversation if you knew he wasn't there? So there was a lot of problems with her testimony. The judge found her not to be credible, and he didn't do that with all the other witnesses as a general rule. And that was the basis that Mr. Carranza didn't call him. So...
But because he didn't call her at the Williams Rule hearing,
Right.
As a result of that, the Horvath fire was coming in. That was very damaging testimony.
I don't know if it was
correct?
I don't know if that was the result of that or not. This was a defendant who had copious voicemail messages and live witnesses hearing him say, "I'm going to burn the house down." He threatens to burn houses down as a routine. He was mad at this lady.
Isn't there a difference between threatening to burn houses down and having actually set a fire?
Well, there is, but there was the method of fire for the Horvath fire was the same as the method that they think was used on the house in question
That's
here.
exactly the point. If the Williams Rule hearing had gone differently, then that very damaging evidence wouldn't have been in the trial, correct?
No, I think that it would still have been admitted. I think that there was still clear and convincing evidence with the incredible testimony from Gilmore, who couldn't remember many things and who had days wrong and who did the affidavit much later. No, she wasn't sure about anything that happened and wasn't trustworthy, whereas they had other evidence that shows he threatened Horvath. He said he was coming down there. Then she hears a boom, and they smell gasoline. They know someone said that, and he had just threatened that he was coming down there. They had enough to say that the two fires were similar, and that was enough there. The jury, it's a question whether or not they believe Miss Gilmore and his quote-unquote alibi.
Mr. Crenty, let me talk to you for a couple minutes, if I can, about the issue that I think concerns me probably the most in this case. Now, strategic decisions of trial counsel are given great deference.
Right.
Let's talk about the decision here on the two possible defenses, the accidental fire
Right.
and the someone else did it. Trial counsel argues those were mutually exclusive. He chose one over the other. The judge found they were mutually exclusive. Heck, the state argues in your brief that they're mutually exclusive. How? How are these mutually exclusive? They're consistent.
Well, but it was mentioned already. There'll be a situation where if you prove it was accidental, we're done. It's good. If you don't and you pin it on somebody else, you can't pin it on Gilmore. She had an alibi. She had an alibi with 3 witnesses. It's not fully discussed.
He doesn't have to pin it on anybody. He just has to say it wasn't me. I mean, mutually exclusive is, first defense, I was in Alaska at the time, it wasn't me. Second defense is, I was there, I did it, but it was an accident. Those are exclusive. You can't argue both of those. This
Right.
one, he's saying both of them, it's actual innocence is what he's arguing. One, it must have been an accident, and two, if it was an accident, it sure wasn't me that did it. Look at all these other people. If you could have even if he had to choose between the two, how did he make the right choice? Seems like the state's evidence on the accidental fire was pretty good with the fire marshal and the canine and everything else. The defense evidence as to accidental fire wasn't that good. The defense evidence on somebody else did it, I mean, you got a laundry list of people who had a motive to do this.
No, I
Enough
disagree.
to raise reasonable doubt anyway. I mean, I don't think he had to choose between the two, but if he did, how was that the right choice?
That was the right choice because they had 5 felons over here that you could pin it on for an alibi or they committed the arson or something happened between them. And then you've got a NASA engineer and expert witnesses who can come in and do recreations and explain them and show them on video and say, here's how that fire started. It was accidental. Once you prove it's accidental, there's no need to do anything else.
Counsel, you agree they're not mutually exclusive, right?
Well,
hold on.
I think based on this record, they might have been, it was a better choice, in my view, to do what was done below.
That's a different question.
Okay.
The first question is, they're not mutually exclusive, right? Trial counsel absolutely could have presented both defenses as an alternative. Hey, it was probably an accident. I wasn't there. So I don't really know. So if it wasn't an accident, somebody else did it, right? That's possible here, right?
That is possible.
Okay.
I will agree with that. It is, you could
Didn't they
say,
know that at the time, well before the trial, they knew that Fire Marshal Idziorek was going to testify to that fire starting in 2 different places under that house.
Right.
So not only were they not mutually exclusive, but was this even the good strategy? Accidental fires don't start in 2 different places at the same time, do they?
there was no accelerant either. They couldn't show that there was accelerant. They were making a big deal about the gasoline on his clothes, but there was no gasoline, and the dog sniff that tested positive turned out not to be. So they had no means of showing, even though it was started or seemed to be started in 2 places, it could have started at the air conditioner, and then something else could have propped up somewhere else, but they didn't have an accelerant. And I think that was one of the reasons why the strongest defense in this case was accident. It solved all the problems. Plus, the preservation issue, if I can dovetail that with it, the preservation was critical because counsel states that there has been no downside to it, but if they had examined the AC and proven that it had not caused a fire, that it didn't short out, that would be the end of that, and we'd have nothing but an arson case. It's important, I think.
I mean, appellant's counsel's point is that had that happened, fair enough, now appellant knows which theory of defense to go with.
Well,
and it would have been the other one, right? It would have been
been
somebody else did it.
It would have been the other one, but that's a much weaker case. There is not enough there to support that. They were trying to pin it on Gilmore, who had an alibi. They tried to pin it on Burnham. He was in the building at the time. And then they tried to pin it on the Kingsman motorcycle group, but there's no evidence in here. Kingsman would have gone after the victim in the trailer instead of where he was living. It just makes no sense. It's very difficult in this case, with this set of facts, to try to prove someone else would have committed it
They
in
don't have
light
to prove
of the
someone else
voicemail.
committed it. They don't have to prove that. They just have to raise a doubt that maybe somebody else did.
With the voicemail, though, that he's left where he's threatening to burn down the homes, and he did that in
The
front of
accidental
other people.
fire is the better defense, and they're going to put all their eggs in that basket. Why not call these other witnesses who lived there or had to live with adjoining walls that could testify about the faulty wiring and the things that happened in there?
That's
Why not
another
put
red
on that?
herring. There's no faulty wiring. There's no showing that there was faulty wiring in the AC unit that ran the trailer. These people were in the apartments.
Accidental fires can come from more than an AC unit.
It can, but they said it was the AC unit. The AC unit was what everyone's talking about at this trial. The AC unit in here, assuming that it was the cause, would have had tripped the breaker. The breakers were working. They had proof of that. The breakers would have tripped before anything happened, either at the AC, either in the main panel, or the thermal control up in the AC
Weren't
should
they
have stopped this.
regularly tripping from the sounds of the witness's testimony?
Just for lights, as far as I recall, and it would trip the breaker.
That's
If-
not insignificant, is it? Wasn't there a code enforcement officer who testified this place doesn't meet code because of the electrical wiring?
Doesn't mean you could because of that, but I believe that was the apartment. They're referring to the apartments. They're not referring, the air conditioner in this case might not have even worked. He asked to have Burnham, I think it was Burnham who testified, he was approached to fix it. It didn't work.
6
It might
months
not have
earlier.
been on. There are many other factors involved with this, that it was difficult to show that the air conditioner could possibly have caused it. But the accident was the best way because there wasn't anything that rebutted it either. That was brought out at the trial. It was the strongest defense that they had because the arson defense, yes, they don't have to prove someone else did it, but they have to show motive, opportunity, and ability, and they didn't have that. They had alibis, unlike the scenarios where the guy's jumping off the roof to get out of the house he just set fire to, and his girlfriend or wife breaks her foot or leg doing the same thing. You'd think they could have planned that a little bit better. And then last, the Kingman's motorcycle group, there's no evidence they knew where he lived, and if they did, they would have set the apartments on fire.
Counsel,
So we're done.
were there both strengths and weaknesses to either, to both of the possible defenses, right?
Correct.
And in that case, don't we have to defer to the trial court's determination on the strategy that trial counsel employed?
I think so, and I think he had the agreement of the defendant on many of these issues, and that there was a constant communication between them. Now, we have buyer's remorse. We have, yes, I did pick the accidental fire defense, but I really wanted him to really pursue the arson too.
What part of the building burned? I mean, my recollection from the record is the entire building didn't burn down.
Right.
Just as I recall, it was the portion of
Most of the trailer,
that the
or-
victim lived in.
Right.
And that the remainder of the building where Burnham once lived was either barely touched or, certainly not burned up in its entirety. Can you elaborate a little bit on that?
Well, I think that that's true. I think it was the smoke that invaded that part of the area and forced them to jump out where they did. But I believe you're right. I believe that.
So the fire wouldn't have started, I mean, there was at least an inference that the fire wouldn't have started in the part of the building that Burnham once lived in, right? I mean, so whatever electrical issues there may have been in that part of the building, there's at least an inference that that wasn't the problem.
Right, correct. And we believe that overall, right, with the judge's order, the judge's careful consideration of everything, the trial strategy that was proven not to be as effective, perhaps, as a defense would have wanted, but it was a viable choice. We would ask that
But
you
if-
would.
the point is, he didn't have to make a choice. And if trial counsel argued he had to make a choice, and the judge found in his order that he had to make a choice, and he made a fine choice, but what if that's a mistake of law? He didn't have to make the choice.
He didn't have to make a choice, but he.
Okay, but what if the judge found that he did? It was argued that he did. You put in your brief that he did.
Well, yeah, but the judge argued that the judge has seen evidence of this before. I believe it was the statement or along those lines. And there are situations, and the judge felt that this was one of them, where it was the better defense, that they're not going to
Mutually
second guess
exclusive.
that.
That's not mutually exclusive.
It's not mutually exclusive.
And he
I
found
agree.
that they were. If they weren't, isn't that a mistake of law that the judge made and the trial lawyer made?
Oh, no,
in
it's
making
not a
the
mistake
decision?
of law. That's a strategic error. It's not a mistake of law.
Well, counsel, if they thought it was mutually exclusive, and it's not, and we all agree they weren't mutually exclusive, then isn't it? It's harder to say it was a sound trial strategy, right? But help me out here. When I can't find it in the record at the moment, it's a relatively big record. But I read this testimony specifically for this point, and when I read counsel's testimony, I read it as, look, we could have offered both, but we were concerned that the jury would punish us for offering both because we would lose. We were afraid that the jury would essentially say, look, you can't have your cake and eat it too, right? Am I just misremembering that counsel's testimony?
No, that's.
He didn't. I don't remember him saying, "Oh, we had no choice. We couldn't. They're mutually exclusive." I remember him saying, "We didn't think it was a wise idea because the jury would punish us, and basically, we would lose credibility with the jury."
He said we would lose the jury if we tried to disprove one and just.
We tried to do both.
Right, exactly. So.
I just didn't read his testimony as saying, "Oh, we didn't have a choice. We couldn't do both. It was impossible."
That's probably more accurate as far as that record goes. He did look at everything. This was all discussed. Nothing was a surprise as far as his testimony explained why he did what he did. And he did look at all of the possibilities, but he did not believe that it would have been as effective. And that was the final determination on the strategy. If there are no other questions, I'd ask that you affirm.
Thank you, counsel. Take your time, counsel. I won't start your time until you start talking.
Thank you, Your Honor. I'd like to start off where Your Honors just left with that question about Mr. Carranza saying that he believed they were mutually exclusive. At the record at 1648 to 49, 1657, and 1685, he said that the two were mutually exclusive, that's what he believed, and presenting them would be harmful. He went on to state later in the record at 1687 and 1688 that the PD had spent $80,000 or $90,000, and had it not spent the money or found what they believed was a suitable expert, counsel would have blamed someone else for the fire. In other words, he is using a mistake of law, a mistaken belief of the law, and the spending of money and being so financially committed to a line of defense.
That's not how I read it, that, counsel. I read that as, look, if we didn't have this other strong defense, which counsel considered strong, you disagree with, fair enough, but he considered it strong. I read that as, hey, look, if we didn't have this other defense that I thought was so strong, then of course I would have gone with the only defense left.
Okay, but there's two problems with that, and forgive me, Your Honor. The two problems are as follows. Number one, he did not vigorously pursue the accidental fire defense. He did not put on Herring, who testified to both the trailer and the apartments. He did not put on Gilmore, who testified to the problems with the AC and the heater and the electrical issues in the trailer. He did not put on Ms. Sessions, who had testified at depots about problems with the trailer and the apartments. He did not put on Mr. Burnham, who had testified about problems in the apartments. Furthermore, he did have evidence of the alternative defense, of the alternative arson defense. He also made a mistake in that he believed he had a burden, that the defense had a burden in order to put forth the evidence. He testified to that. There is no burden. As long as it is colorable and you're not violating the rules of ethics, there is no burden. that alternative defense was equally, if not more, the defense to go with because of the fire marshal's testimony.
Counsel, how can we second-guess the trial court on that point?
We don't have to second-guess the trial court, Your Honor. This is not a matter of second-guessing the trial court or of counsel. Counsel proceeded under a mistaken belief, an actual conflict of interest, a mistaken belief of the law, counsel didn't...
What was the mistaken belief of the law?
They were mutually exclusive. They're not.
That's not how I read his testimony. Can you point me to a page?
I did just a few seconds ago, Your
And
Honor.
I'm looking at 1648 through 50. I don't see it.
Yeah, he said at 16, counsel believed the two were mutually exclusive and presenting would harm his credibility, 1648 to 49, 1657, and 1685. He also believed there was no support for the alternative arson defense at 1691 to 1692. And this is the record on appeal. This isn't the supplements.
Did he believe they were legally mutually exclusive, or that from a strategic perspective they were mutually exclusive, that he felt he would lose credibility with the jury if he tried to pursue both of
I
them?
believe he believed both. He certainly said that he would lose credibility, but Your Honor,
So you agree that my reading of his testimony is accurate? He said, I was concerned we'd lose credibility with the jury if we presented both.
I said that a few minutes ago. I
Okay.
did say that.
All right.
Yes, Your Honor. I'm
I just
sorry.
wanna
I'm
make
sorry if I
sure.
wasn't clear. I did say that a while ago.
Okay.
But he also, they were not mutually exclusive, and he continued to say that throughout the hearing without that qualification that he would lose credibility, that they were exclusive, and they certainly are not. An exclusive or an inconsistent defense is one which negates the other defense. This is not, I wasn't there, because I was in Michigan when the fire happened, but yet I set the fire. That's an inconsistent defense.
We understand. I think the question is what did he mean by mutually exclusive? Did he mean mutually exclusive as far as what the jury's going to buy, which would be a strategic decision, or did he mean legally mutually exclusive?
Your
right?
Honor, I don't know what is in his head, and
But when he said, look, the jury would punish us, they would not believe us, we would lose credibility with the jury, why isn't that enough? That's a strategic decision.
Your Honor, it wasn't based upon sound trial strategy. To point and to Judge Harris here, these weren't exclusive. You could have offered both. The stronger one was the arson.
But you keep going to the legally mutually exclusive. That's not what I'm talking about. I'm talking about what the jury is going to buy. At trial counsel, I don't want to present both, even though I could, because, man, I think the jury is going to punish us for doing so.
And, Your Honor, I would posit that the jury would not punish a defendant for saying the following, which is the way to have presented this defense. Members of the jury, we believe this is an accident.
No, I understand how it could happen.
I don't know how he
So
could
every single time defense counsel has more than one defense that is not legally mutually exclusive, if they don't present them all, then it's per se ineffective assistance.
No, Your Honor, I'm not saying that. What I'm saying is in this case, under these facts, under these circumstances, with the actual conflict of interest that you asked about, and I had some page sites.
Tell us about the conflict of interest.
He represented Burnham. Mr. Carranza admitted, the PD admitted that he was representing Burnham. Burnham asked him about cooperating, and then supposedly he got off. However, he was on another case, and he remained on that case for Mr. Burnham. Mr. Burnham received special treatment on both cases, one of which was no billed, and that's in the record. Their office also represented Ms. Gilmore at the same time, represented Ms. Sessions
Counsel,
at the same time.
do we need factual findings on the conflict issue?
The court did not make them.
Do we need them?
And yes, I don't believe so. I think you have a record. I think it would be preferable for this court, in all honesty. I think there is enough to grant a new trial based upon the record here, reverse and remand with instructions to grant a new trial. But also believe that there are many findings the court did not make. For example, the court did not make any findings on the argument that Ms. Gilmore should have been presented at trial, her testimony about the alibi. There were other things, the actual conflict that was not ruled upon. So the court failed to consider the matters under 3.850 sub F sub 8. He did not rule upon everything listed in the record. And may I just conclude that thought? He did not rule, and because he did not rule, I would suggest, at a minimum, remand with instructions for either refuting the record, attaching the portions, or an evidentiary hearing or findings.
Thank you, counsel.
Thank you, Your Honor.
All right, the court is adjourned.